from the SIS point of view?
Thank you very much indeed. Having dealt with these sorts of issues for 25 years, I do have quite clear views, some of which have been sort of voiced by other speakers already, others will be novel. Basically, the problem for doctors is that a single incident can result in a multiplicity of procedures. And you often find when people are under attack, and that's certainly the way that it's perceived by the person on the receiving end, that it seems that there's a never-ending torrent. And just coping with the correspondence and coping with the rest of life can be a major problem. And one good thing which I think has happened over the 25 years I've been involved in this is there has been less secrecy about adverse events, and people are a bit more supportive of each other than they were in the past. But my first thing I would like to say is that if something has gone wrong, you need to tell people who can help you rather than try and muddle your way through. Now, when it comes to complaints, we've heard from Peter Walsh about candour, and he referred to good medical practice and what the GMC expect. The GMC expect you to act immediately to put matters right and offer an apology and explain fully and promptly to the patient what's happened and why. So basically, that is the expectation from the professional regulator. And by and large, I would say it's a very good approach. When it comes to dealing with complaints, you can either make things better for yourself or worse for yourself. Robbie's Law, which is what AVMA would like to see, stems from a case which is perhaps the exemplar of appalling complaints handling. In that particular case, there were a number of things that went wrong. People basically changed their story. There was, in fact, an alteration of the medical records, as far as I'm aware, which was admitted. And it's not surprising that the father of this child, who I believe died, in fact felt that no one was telling him the truth, that as a matter of expediency, he was being told the first thing that came into people's heads. And, if you want to drive a complainant on, then that really is the way to do it. If you want to get a complainant to understand what has happened from your perspective, then candour is the way forward, whether there is a statutory responsibility or not. But before you do that, you do actually have to understand the facts yourself. And one of the things that we see time and time again is that people are panicked into providing a response before they themselves understand what has happened. So understand what the complaint is all about from the complainant's perspective, make sure that you understand yourself, and then explain what has happened to the patient. And if it's appropriate to apologise, don't be afraid to do it. It just stinks when something has clearly gone wrong and someone has made a mistake, if that person then tries not to apologise for something which clearly should be apologised for. So I think that when it comes to complaints handling, if it's done well, it can actually prevent an awful lot of things from being pursued further. And we need to get away from this myth that complaints are precursors for litigation. By and large, most complaints do not progress to litigation, and as I said, if you want to try and up the chances of that, the best thing is to stonewall. So when it comes to clinical negligence claims, claimants have to prove three things. First of all, that they were owed a duty of care. That is just a written when it comes to doctors treating patients. Secondly, there was a breach of duty, and third, that harm was suffered as a result of that breach of duty. And the only remedy available is financial compensation. That's all that the law can do. So when it comes to the standard of care, many of you will know all about the Bolam test. Poor old Bolam was injured back in 1953 and still makes regular appearances when these matters come to trial. But basically, what it says is that you are not guilty of negligence if you act in accordance with accepted medical practice. So provided there are people skilled in that particular area of practice who will support what you did, then your case will be defensible. Sounds simple. When you come to do deal with clinical negligence cases, everything is teased apart in fine detail, and you will look at numerous points along this patient's pathway to determine whether or not what actually took place was up to the required standard. So, although it's often described as being a sort of bit of a doctor's charter, I don't think that's true. The Bolam test is a good way of assessing whether or not care was adequate, and in fact, in many ways, in long and complex cases, it is incredibly demanding of the medical professionals involved. But when it comes to surgical cases, an awful lot of those really revolve around consent and failure to warn of particular problems that may occur. This statement from 1914 and a New York court basically summarizes the requirement which exists today to make sure that patients consent to treatment. If they do not, then unfortunately you are guilty of negligence. You might say battery, but in fact there are always cases sued in negligence. Now, when it comes to a valid consent, three things are required: competent patient, patient's informed, consent freely given. And when it comes to competence, there is a case which I'm not going to go to in any great detail, but if patients can comprehend and retain the treatment information, believe it and weigh it in the balance to arrive at a choice, they are competent. And there is always an assumption with adult patients that they are competent to consent. More importantly, and this is where perhaps things have changed over the years, well, it's where they have changed over the years, is information. And these are 4 cases, 3 from the UK and 1 from North America, which demonstrate how the law has evolved over time. Hatcher and Black was a case involving a BBC announcer back in 1954, and she had thyrotoxicosis, she had a thyroidectomy. Prior to that, she asked if there was any possibility of any effect on her voice when she had this throat operation. She was reassured very strongly that there could not be. You've all guessed that her recurrent laryngeal nerve was damaged, and she was hoarse as a result, and so she sued. Now, in those days, there were juries for clinical negligence cases, and the judge in this case was Lord Justice Denning, who was a very outspoken man from Wiltshire, and he basically heard all the evidence, and having heard the evidence, he said that none of this surgeon's peers have condemned him, and turning to the jury said, and neither should we. Now, basically, he was therefore condoning a very paternalistic approach to consent. That obviously is not something that we would hold with today, but that was the standard back in the 50s. Come 1972, Canterbury and Spence, and all these other cases are spinal cases. There was a 16-year-old with a correction of a spinal deformity, and basically he was not warned of the chance of damage to the spinal cord, and this was the case that gave us informed consent. This was the case where the judge said that a patient prior to a procedure must be provided with all the facts which were material to their decision, and that summed up informed consent. Now, in the UK, we rejected that in the Sidaway case in 1985 because the law lords found that it was up to the doctors to determine what information should be disclosed to patients. So in Canterbury and Spence, we had the concept of the prudent patient. And in Sidaway, we had the prudent doctor test. So there was a big conflict between the two. And that was actually resolved, funnily enough, by the GMC, who in 1998 produced guidance on consent, which brought informed consent theory into the UK for the first time. And the only other development since then, really, has been the case of Chester and Afshar. And in this particular case, which is the most misinterpreted of all, basically the courts found that there was a duty to provide the information, and that a failure to provide information in itself was sufficient to recover damages. You didn't have to say that, but for providing that information, the patient would not have undergone the operation. So we've undergone a big change in the way that we look at consent in this country, and for my money, consent is the biggest single issue in relation to surgical negligence cases. I'm not going to skip over that. When it comes to compensation, what the law is trying to do is to put the claimant back in the position that he or she would have been in had the negligence not occurred. Clearly impossible, but that's what the objective is. And so you say, okay, well, there are two lots of damages. First of all, you've got general damages for pain, suffering, and loss of amenity. And then you've got special damages, which are all the things that you have to pay for that would not otherwise have occurred. So it might be that you need to have a special motor car, it might mean adaptations to the home, it might mean financial losses due to loss of employment, or basically the need to provide financial support to dependents. All those sorts of things come in special damages. And I want to run through a case in a moment, but it's worth looking at first how things have changed. So in 77 we have the first £100,000 claim, 87 the first £1 million claim, and last year there was a cosmetic surgery claim which was settled in the courts for £6.3 million. Peter's already been through the NHSLA figures, and we're going to come back to legal costs because that is my bête noire. Now, you can look at the costs associated with clinical negligence in all sorts of ways, but Frank Dobson, as the Health Secretary, came out with this particular quote, which is perhaps the thing that he is best known for amongst clinical negligence lawyers of all sorts. The best place for a lawyer in a hospital is on the operating table, not sliding around causing trouble for other people. And there is really quite a perception these days, despite the comments that Peter made, that there are a lot of people who are trying to drive the notion that you might be entitled to compensation, whether it's PPI claims or whether it's to do with clinical negligence, slips and trips. I'm afraid the fact that all these advertisements appear on television so frequently illustrates that this is now an industry. And although there are many people who do deserve compensation for significant errors that should not have occurred, there are also a number of people who are trying to get an enormous amount of money by providing legal services to people who perhaps otherwise wouldn't really worry about whether or not there was a claim. So let's look at this big case that was settled. This is a case of Mrs. Johnson, and the surgeon was Mr. Fourie. She had a facelift. So she basically owned an IT company, and she underwent this thing called a minimal access cranial suspension facelift, and that resulted in damage to the right facial nerve, and as a result she had an uncomfortable twitch, and that, she said, meant that she could no longer run her IT company. She then made a claim, and on the surgeon's behalf, the MDU admitted liability. So when this case came before the court, they were only interested in a few points. First of all, what damage has occurred as a result of negligence, and what was the compensation that was required, and lastly, what were the legal costs to be. Now, we've already been through the fact that there will be general and special damages. So her general damages for pain, suffering and loss of amenity were estimated at £80,000, and because this had happened some time before, there was interest to pay, so that came up to £86,000 and a bit. So that's all that she was awarded in relation to pain, suffering and loss of amenity. When it came to her special damages, you've got to look at the ones that the damages to date and the damages going forward. So if we look at the past special damages, you can see that she's got miscellaneous losses, lost earnings of 1.7 million, and interest on that. And then if you look at her future losses, lost earnings, 4.2 1.17 million. So altogether, her special damages come to £4.2 million. So add that to the generals and you get to 6.19 million. So that's her damages. The cost in this case, I don't know, but I'm guessing that the claimant's costs will be between £2 and £3 million, and that the defence costs will be somewhere in the region of £500,000. I may be wrong, but those would be sort of standard proportions in cases like this. So costs are a very, very significant part of clinical negligence claims. And the paradox is that for lower value claims, they can often outweigh the damages awarded to the claimant. And basically, when you're looking at these no-win, no-fee arrangements, successful claimants' lawyers are entitled to what they call an uplift of up to 100%. So if your standard charge as a solicitor is £300 per hour, if you can win one of these cases, you charge your time at £600 an hour. And so it doesn't take long for these things to actually climb to very significant levels. So when it comes to compensation and claimants, people often think that there ought to be a link between the severity of the harm and the compensation paid. And that is true, there is, between the severity of the harm, but that's not to be confused with the degree of fault on the part of the surgeon. It is all to do with putting that patient back into the position that they would have been in. So there you are. It was one of the sort of famous phrases, it's not what's done, but to whom it is done. And I've already said that costs often exceed the award to the claimant. Now, when it comes to cases like this, it brings home the fact that insurance policies actually have indemnity limits. And the limit is the maximum amount that the policy will pay out in any 1 year. And you can see that in a case like this one of Johnson and Fourie, that if you add the 6.2 to those estimates of legal costs I've given you, it's not far off a £10 million limit. So when we're talking about limits, we're always thinking about how bad could this be and what margin do we need to build in. So when we talk about limits, we talk about big numbers for that reason. Now, I think there are a number of outstanding issues, and these are the things which I think that we all need to take away. We do not have any public policy on appropriate levels of compensation. And there have been a number of cases where very large sums of money have been sought by claimants. There is one case which involves a professional footballer. It's called El Safti. And in the El Safti case, the judge did make, at the end of his judgment, comments about the affordability of insurance if there was no limit on the amount of compensation paid to patients. Now, I'm not for a moment suggesting that children who suffer from cerebral palsy as a result of brain injury should have a cap put on their particular compensation awards, because they're calculated in a very special way. But when it comes to loss of earnings for maybe professional sportsmen, maybe the sort of business tycoons and all the rest of it, I think that we do have to ask, what is a reasonable limit to put on these levels? Because if we don't, then all that will happen is that insurance costs, indemnity levels will have to increase, and that will, I think, have a detrimental effect for us all. The second is that something really ought to be done about legal costs, and there is a report by Jackson, and that may well result in some changes. The jury is out as to whether or not that will actually cap things. We will see as the NHS changes that indemnity provision will change, and I think that for individual surgeons it's very important always to ask yourself, I'm doing this work, am I indemnified through the NHS, or should I be carrying my own indemnity? and people who aren't sure should seek clarification on that. Claims inflation isn't an outstanding issue, apart from the fact it runs between 6 and 7%, and that's obviously going to drive up indemnity fees over time for the majority. And all this really comes down to, what is going to be affordable in terms of indemnity for independent sector practice, because ultimately, if everything goes up and up and up, people will find themselves in the same position as obstetricians and neurosurgeons who sometimes think actually that their subscriptions are greater than their potential earnings in any given year. So basically, those are the issues which I think we should be concentrating on, and that's me at an end. Thank you.